So you're kind of the guy that hopefully from like a field op standpoint, you never have to interact with. Like you're construction litigation attorney, right? And I think maybe just to start out, from my background, I was really never thinking construction litigation, right? As a PM in my 20s and 30s, I was thinking like risk avoidance, risk management. But maybe from your experience with just all the cases you're interacting with, is there a pretty big delta between the kind of expectations from the field ops kind of community and what you know to be true of just how many cases end up or how many projects end up in kind of formal dispute?
Yeah, great question. Just a quick background. So I'm a construction trial lawyer. In trials is quite a bit different than litigation. I'll just go over it really briefly.
So I blew the entrance already. What is the difference? Can you tell me the difference?
I'm quiet, Stephen. I'm quiet.
So the primary difference is trials is mostly going to be about witness credibility, and that's what we're going to talk about today. How important witnesses are. Even the lowest level guy can make or break a multi-$100-million case. So what I want your viewers to take away from this discussion today is that it's really important from the lowest level guy. You got your PMs, your supers, even the lowest level guy. He matters. He matters on the project. What he says matters. His credibility on the stand matters. So to answer your question, in particular, the issue has to deal with when you take a young PM who's sending out a bunch of emails. I'm going to use an example really quick. I had a case involving a gentleman. He was probably, I'd say he's 25, 26 years old, okay? He was a PM, and he sent about 5 emails that were probably done at the end of a long day. You know, maybe this is the start of his career. He's a little bit challenged. Maybe he's tired. And those emails ended up being Exhibit 12 in my trial. And they were serious emails, pretty bad. I mean, very difficult to get around, very difficult statements in them that made conclusions and opinions that probably shouldn't have been made. So I think that's what we're going to talk about here today. But that's kind of the introduction about, the difference between trials and litigation. Litigation is about all the procedural mess, right, of just getting to trial. But trial's all about people. It's about people and credibility.
Man, where's that guy now? Maybe we should have him on the podcast next. See, just to get a live update. Right?
Yeah, that would be interesting.
He's probably in software now, to be honest.
He's probably in DevOps. So I think it's an interesting point, though, of, you've made this a couple times, even in some of the pre-conversations, of the importance of those frontline people to understand kind of the grander context, right, in which the world they're playing in. So maybe just to dig into, do you want to get into that case where the young PM was kind of on the line for those 5 emails?
I can get into a couple cases. I probably have 3 examples that are really good. The first one is that particular case. This was a young PM. He sent some emails that said things that were quite damning to their position. Things like, "Are we still using the bad stuff?" Things like that. You don't want to. The most important thing you can do as a PM or super is observe and report, right? We're going to come in, we issue our daily reports. Those things are informational, they're descriptive. They're not conclusory. They don't state conclusions, they don't state opinions. So that's the first bit of advice I can give, a younger PM, younger super, what they're doing. They need to be focusing on observe and report. You state the facts. You don't state conclusions, you don't state opinions in emails, because those opinions and emails, one day they're going to be thrown up on some projector in some some courtroom, and you're going to have some lawyer like me cross-examining you about those emails. So don't do that. Don't be.
Put those in your WhatsApp chat.
Yeah,
that's probably subpoenaed as well, huh?
Well, it's an interesting thing. Emails are much easier to get. Slack, for example. Those kind of instant message relay chats, of course you can get them through discovery. I will tell you, though, that practically, while you can get them, they're much, much harder to get. Slack, Google Meet, all those kind of instant message relay platforms, very difficult. I've only seen one of those ever used in a case. Typically, though, it's all emails. Emails are where the problems are. And I think, frankly, the reason that emails are a problem, unlike in the instant messages, is the instant messages are often, they're impromptu. They're just stating people's thoughts as they come. The problems with emails a lot of times is somebody will sit there and they'll think about what they're going to say in the email, and they'll actually think too much, and they'll start offering conclusions or opinions that they really shouldn't be drawing, opinions that they're wrong about. They don't know the full scope of the project, or they don't know this particular issue, and they'll state an opinion as if it's a fact. That's a huge issue.
So let me ask some clarifying questions here. So we're talking with a young project manager who's working for a prime or general contractor, correct?
That's right.
Discussing performance issues with a subcontractor, a trade subcontractor, correct?
That's right.
Okay. And so, the nuance of what I heard you just described was like this, something about materials, like, oh, these aren't the right materials, or, okay, so then I can only draw the conclusion that was someone doing something that they shouldn't have been doing.
So what
right?
they were, yeah, you're
and,
right.
And I don't know how much you can get into, but I think it's important for the listeners to truly understand context here, because as I think, well, is Garrett, attorney telling me not to send an email to sub, or in fact, should I just be sending serial letters if I'm ever communicating with the sub?
Yeah, that's very good. No, the advice is don't not send emails, right? That's not what we're doing. The advice is send emails that are descriptive, not emails that are prescriptive. We're not sending suggestions. We're not sending emails about opinions, particularly if we're a super or a PM. You don't have all of the knowledge of the entire job. You just simply don't. You're not the architect. You're not one of the subs. You're not a material supplier. Your job is to collect information and be descriptive about it. It's not to articulate a conclusion or opinion. So that's the number one takeaway, is don't articulate conclusions or opinions that you don't know are absolutely true. I'll give you another example. I have a case I was just telling Stephen about before we started this. It was a subsidence case. 2 houses, really interesting case. Big, huge hill like this. This hill had a retaining wall at the top of it, okay? And the retaining wall broke loose. And ultimately, after the retaining wall broke loose, the entire hillside came sliding down like this and smashed into a bunch of houses down below, okay? Took out the houses. Now, the city, who was involved with maintaining that retaining wall that was inside common area, not on any particular person's property, they had a person there, a young person who was a superintendent of the city's work that was doing this work. And that person wrote a very bad email that ultimately allowed me to settle the case, because that email said, hey, should we be putting this stuff? And it was a particular, it was a barrier, like this water barrier that they were going to put. Hey, should we be putting this stuff on the bottom here, even though we know it fails? I mean, that's the kind of emails that you don't want to send. You don't want to state your opinion about whether or not that particular product is a failure or not a failure. The correct answer to that email that you should have sent is, hey, I don't know what we're using for this. Who do I go to get more information? Right? We're being descriptive. We're asking questions.
Okay, and in that instance, was he even of the? Did this individual have the correct experience to even make that conclusion or that very prescriptive statement, rather than
not?
Right, exactly, absolutely not. So again, I think, so if I'm a general contractor listening to this, or if I'm a subcontractor listening to this, the advice is, like, ask questions, don't formulate opinions and share those opinions. Be very careful with it. Be very careful with opinions, because in that case, a certain individual had an opinion, and because of that opinion, whether fact or fiction, right, mm-hmm. you were able to use that in such a way to basically get the outcome that you and your client desired. Which I'm sure was the right outcome for you and your client.
It is,
right?
It is, certainly. But you're hitting on something super important that I want to make sure that we discuss, which is, yes, that person didn't have the expertise, which is bad. But what makes it actually worse is that this person, all they had to do was go and talk to an expert. There was an actual expert on this site, a soils engineer, who could have told them exactly the answer to this question. And think about this for a moment. When I go before the jury, all I need to do is show them a picture and this guy's email. Now, he's going to get up on the stand and say, I didn't know that. I made my mistake. I said it poorly. I didn't write it correctly. He'll try and walk it back like they always do. But that's not going to help the 18-year-old Starbucks barista who's sitting in my jury. Like the moment that she sees the picture and this guy's email, it doesn't matter.
It's done.
It's over. It's done. The guy's cooked. So go ahead.
Well, I think there's a couple different ways to consume what you're saying, and I think the wrong way is to think like everyone has to approach communication on a project with like this like CYA angle, and they have to like neuter any kind of like suggestive language. I think what you're saying is, hey, you need to approach the project collaboratively, but also understand where the different lanes of liability are, and kind of stay within those lanes and ensure that you're leaning on the folks that are owning those other lanes of liability, right?
Right. 100% in staying in your lane. A good example of that. I have another case I can give you an example of not staying in your lane. This is a large horizontal construction project. It's about $2 billion. It's very well known, so I won't state it generally. I'll state it generally. It's a rail project, and on that particular rail project, there were a number of supers and all those other kind of folks. And one of them, I will remember, he was tasked with just managing the documents. Okay, there's a document management system. This guy was probably early 20s. Okay, that's his entire job is just to manage the
What type of documents? What type of documents?
Construction documents, RFIs. All that
submittals, just everything.
Exactly. That was his only job was to do that. Okay. Now, what you sometimes get with folks like that is they're aspirational. So they'll try and go do something else. Problem is, he showed up and
This sounds like me, Lars. This might have been me. Was this me?
Explains so much.
Keep going.
He ended up starting to connect with and talk to the design builder. So, this is a design build job. He's with the contractor. He's talking with the design builder. There's no reason for him to be talking with the design builder, particularly over email. And he was asking questions about the RFIs. That's not his job. His job is not to be asking any questions about the RFI. That's somebody else's job. He was supposed to stay in his lane and just upload the documents. Now,
man, I feel like I'm taking the side of all the losers in this narrative here, but like. I mean, this guy is like, he's doing his thing. He's like shuffling through documents, PDFs, and he's just like kind of tired of it, right? And he's like, hey, I'm going to like step out and I'm just going to ask some questions. I mean, in any other context, if that didn't end in litigation, I'd be like, way to go. No? Lars, back me up. You owned a company. Isn't that the kind of agency you want from people?
You want people to show initiative. You want people to... But you don't want people to create freaking messes.
Yeah, right? That's fair.
And now the inhumane job of just being the dude that manages documents, like talk about like, again, it's 2026. I don't know what year this was, what decade it was, but it's like, come on, we should
like last week.
Really, yeah, it was last week. It's like really full-time person. Like you got to be kidding me, right? Like, come on. But the real issue I think around this is. We teams have to be able to ask questions, and you can't be fearful of sending an email and asking questions. But I think in how I was trained was I'm just the builder. That's all I am. I'm here to ask questions and coordinate between my trade partners and my designers. What risk do I have? I'm here to ask questions. I'm here to help coordinate. I'm not the expert. I'm not the designer. I don't hold that license. And I'm not the plumber. I'm not the HVAC. I'm not the concrete guy. They're the experts. And I think if you look at how some of the really big companies operate, they take that, they do an exceptional job of pushing risk back in all directions rather than being the punching bag and receiving it all. The contractors I see that struggle receive it all. Mm-hmm. It's a disaster. It's an absolute disaster. And a lot of that is, I believe, around leadership and culture and how the company conducts basic operations, basic communication, things like that.
So agency, you're right. I mean, I want my associates at my firm to have initiative too, right? But I think the main thing, the takeaway is, at least for folks that are listening, superintendents, PMs, you need to think every time that you send something. I know it's a little scary to think, but every time you send something, think, is that going to be Exhibit 12?
Is Garrett going to read this?
Mr. Mott,
Yeah.
tell me what you meant when you said this.
Yeah.
That's right.
And you're like,
I know,
crap, I shouldn't have said that, right? Oh no.
And I know that's very difficult. It's very hard. It's very hard to do. But it's just something to keep in the back of your mind because it helps set your expectations about what's going to happen in the future. I can't tell you how many times I've had people send emails that they wish they didn't have sent.
Well, I think if we're talking, lessons learned and advice moving forward, right? Some of the best advice around those sort of like crucible moments, those make or break moments on a job. Oh crap, what am I going to do? Sleep on it. Ask for advice.
Yeah.
You're not alone, right? Ask a mentor. And I think like there is a component of you don't. Again, I think I just go. Don't be the expert. Phone a friend. And being, I appreciate what you said. Descriptive rather than prescriptive.
Yeah.
Is exceptional advice. Exceptional advice. I will share with you the times that I've had challenges with owners or challenges with subs. It always goes back to, and even when you talk internal policies and procedures, like how things move in companies, it's like, all right, Mr. Herman, all right, this is the judge, right? All right, Mr. Herman, or the attorney, like, what did you think was going to happen when you did the following? Oh, crap.
Actually, on that point, I'll tell you a legal point about that, being descriptive versus prescriptive. If you're descriptive, the best PMs I've ever met, best supers I've ever met are guys who treat their daily logbook as descriptive. They come in there and they write everything down. This happened at this time with this person. They write the name of the guy. This is what happened. All of that. That is awesome. That's gold standard stuff for us lawyers because we can take that information and eventually on the stand, I get to put his book up there and I say, hey, you are a really diligent guy. You wrote down everything in here. I want you to tell me what you meant when you wrote this. So he gets to elaborate more and the jury finds him very credible. But what happens instead, if you write something that's prescriptive instead of descriptive, is you don't get to ask the question, what did you mean by this? The guy's going to start crossing you already, right?
So you've already said them what you meant by it, right?
You've already said that.
You've
so
already formulated your opinion
flexible.
3 years ago. Ugh.
That's exactly it.
And I think part of this is just waking up to the reality of the world in which we live, right? Which is, I think, if you talk with anyone on the C-suite side for a GC of any size, they've spent time in litigation. And so it's part of their context in which they operate, right? They just, every interaction, they have that in the back of their head. And even though, and this is, a statistic that I'd like you to back up or question, 20 to 30% of commercial construction projects end up in some kind of formal dispute. Does that sound right, Garrett?
Well, that definitely sounds right to me. I in particular, I would say within the last 10 years, my practice has changed considerably from doing transactional work to litigation. And I see that, when I see that happen, it's happened twice. When I see that, the arc typically means that there's something going on in the industry. So I would agree that it's probably higher than that. I had one just internally, I did it myself. I had about 80 cases last year. I would say of those 80, 10 were transactional.
All right, sponsor break. Lars, real quick. When was the last time you got a new set of drawings from an architect and they didn't cloud anything?
Well, the one that cost me a couple $100,000 was back, I think, in 2017. So, yeah, lesson learned there.
Yeah, so what I like about what Trick Tools is building is they're looking at tools to help kind of remove the mundane from the job site. And, I, same as you, every time there was a bulletin or an addendum, I would go back to the designers and ask them to at least highlight or give me a cover letter on the changes. And that was always like pulling like teeth. But Trunk Tools is now automating that. So you get a bulletin come in, it automatically highlights the changes. You don't have to do a thing.
Well, it's also hitting RFIs, right? It's also hitting submittals. And when we think about standardizing ops, right, and providing that, sort of resource to those field operators, what I see it as, it's sort of like this like mentor within the company that structures, standardizes, keeps it moving in the right direction, looks out for risk. And just this last week, I had a QC manager just pass along a submittal to an owner without doing a review because he was too busy, and it was wrong. And the classic owner statement is, did you even review this, right? So this to me is carte blanche. We absolutely did. And think about getting that first pass before your field manager ever even actually has to do the first pass. Someone's doing it for them. So to me, it's about speed. It increases accuracy and helps standardize ops out in the field, right?
Yeah, and this is the kind of AI that we've talked about on the podcast, really appreciating, right? Which is looking at ways to elevate the craftsman at the heart of project delivery.
Give me time back so I can be out in the field managing risk, right?
Yeah, 100%. Yep. So, all right, if you're a little curious, check it out, trunktools.com/podcast. And if you mention Construction Conversations, you get a discount.
Demos are free, and and you guys get a discount. So let's go.
That's right.
And what do you mean by transactional versus other?
So, just stepping back for a moment. So transactional versus litigation. Transactional just means I'm drafting the PSA, purchase and sale agreement. I'm drafting a subcontract.
Like general counsel kind of stuff.
Contracts.
Negotiations. Mostly contracts.
Non-litigation, non-contentious, difficult. Someone was hurt, someone was harmed, things like that.
That's right. But litigation, it can come out of anything, right? I've got insurance claims, bond issues, license violations. I mean, the world, particularly...
God, who are your clients, Garrett? Jeez.
And you know what's crazy about that, too, is everybody has it. I could tell you right now that every GC in the ENR, they all have a license issue that I could find. All of them do. They all have one. And I had one of the largest license issues. It's a published decision, SR 91, ever. And in that case, the licensing issue, got changed on appeal. The law got changed. But you can get affected by a licensing violation from the smallest, tiniest little mom and pop contractor all the way up to your big guys. They've all got it. So it's just that they're not always enforced. Sometimes they don't know about them, but I could tell you a lot of stories about licensing violations.
Wait, do you represent DAWs?
No. Probably should.
I'm just trying to understand the full relationship context here in this podcast.
No, we met at a conference.
Was it at the same conference
Blueprint.
We all met?
Yeah, Blueprint.
Craps, dude. You guys remember that? You guys remember the craps table? Were you there, Lars?
No.
Dude, Garrett went crazy.
Yeah.
We did really well.
Look at his suit. It's like shark skin. It's like Italian mafia. He's got like red hair. It's ridiculous.
Listen, if any listener ever finds themselves at a crap table with Garrett, just do move for move, whatever.
Do what Garrett does. Do what Garrett does.
That's easy.
I want to hit on, I think, a couple things. Again, I'd say that interacting with attorneys in construction is not a bad thing. It's part and parcel of business. License issues. It's just part of business, right? Disputes. It's just part of the churn on projects. And I think there are certain qualities of a company and management and managers that I think can certainly mitigate it, but you can't prevent stupid external to your organization. You can do so much, but sometimes people just make really bad decisions, and they will cost your company a lot of freaking money. Go ahead.
Let me give you a funny one about external stupid. So we were building this very large Class A, about 150 units out in Pasadena. Building is basically complete. Okay, the subcontractor who was doing the plumbing and the sewage
Dude, I was like, is there water involved?
Oh yeah,
There's water involved.
This one's worse. This
No.
So the whole project gets built. They concrete over everything. The whole building's all ready. A couple months in, somebody goes, "Hey, what's that smell? What's going on?" And then we find out. We jackhammer down.
Destructive investigations. Yep. Yeah.
ET. We go in. We open that thing. We open up the hole, and we find the funniest thing that you've ever seen. The guy, the subcontractor, forgot to connect the sewage line to the sewer at the last, couple feet. And so we're talking, this is months of stuff that's in there, right?
Build up, pressure.
Build up, a lot of build up. And there's months of it. And so it's coming out everywhere.
All
over the property.
All the stacks, like third floor stuff. Like it's there.
Everywhere. It's in the ground. It's contaminated.
No.
There's stuff everywhere. Unbelievable. And all of it was due to one guy who just forgot to connect. I mean, I should show you the picture. This thing is 2 feet. 2 feet is all he had to do.
He probably was about to, and then he got a text, and he was like, "Oh shit, I'll be right back."
I mean, you see amazing stuff like that where people they'll forget.
So okay. So this is super interesting. What's the right phrase here? Oh gosh, it's like knowing intent versus unknowing, right? It's like, did this individual decide he or she was going to do it, or was it like, oh crap, I forgot, right? That intent, intent to harm or whatever. So, but this goes back into, I rarely, and by the way, Stephen, I mean, this and Garrett, I don't know if you just saw it, but did you see the parking structure that collapsed out in Philly at the CHOP, Children's Hospital in Philadelphia? Oh, dude, look it up. Bad news. People died. Absolute travesty. And I remember at a certain project here in Southern California on a base, they were building a hangar and accident, right? Forklift up in the air, drove over a trench, just tipped, right? Like, not good. But it's like, why, whether it's safety, whether it's quality, why are those things occurring? Is it distractions? What are the things causing distractions? I'd love to hear, ultimately, what did they determine? I was sick that day and someone just started backfilling? What happened?
So I've had a lot of cases. I've tried a lot of cases. I can tell you I have maybe 3 in my whole career that were intentional, that were fraud, that are actually intentional. I think most of them, the vast majority of cases, are negligence. They're just people who they're not committed to their craft. There's a lot of scheduling issues. There's people who aren't checking others, right? I mean, I am a huge believer of a CM on every job. I know a lot of people don't like that. I love CMs. I think that they help solve a lot of problems. I've got one right now that I installed. I forced the CM on the job against the contractor's will because I told him that he needs to have a CM or I'm going to sue him. And it's all because you need backup. You need people to watch these people.
What's interesting is, speaking from personal experience, building on the government side, right? And Stephen, you know this. The government requires an insane amount of people on a job, right? Yeah. Superintendent, safety, full-time safety manager, full-time quality manager. But what's real interesting is quality, 3 phases of inspection, preparatory, initial, follow-up. And when you think about what you just described, it's like, okay, preparatory plumbing, okay, talk to me about what you're going to do. Initial, day 1, all right, let's go. Follow-up, okay, final connection. Yep, that's going to be important. Each floor, yep, those elements of check-in are really important. I want to visually inspect. And I don't know how, and in that case, the government actually pays the prime to perform those CM activities. That's that role. But I don't know how people just go and slam some stuff together. Because honestly, that's why there is litigation, because they're just throwing stuff. They're just throwing stuff. And
well, I mean, I think it goes back to construction is not a monolith, right? In the same way in which Whiting Turner or the big boys or a lot, top 400 ENR has a very formalized QC program. 100%. And like Whiting Turner, we implemented the 3 phases of control system from the
across
DoD world just across at least the San Diego region.
Because it works.
But in that same breath, talking about Whiting Turner, you can talk about a local general contractor who's maybe doing a few jobs and maybe even in a commercial capacity, and they're both kind of lumped together. And so when we're talking about these
Correct.
kinds of challenges, there's a huge spectrum in quality, but it isn't always viewed that way because it's such a large, fragmented industry.
100%.
Particularly,
And someone can always do it cheaper. I know a guy.
Yeah. And on public jobs, you're talking about public jobs. DBEs are on there. A lot of DBEs are much smaller, right? They're very needed. We need DBEs, but they're smaller. They're typically less sophisticated. They typically have less programs in place. So when you put a DBE who's maybe a mom and pop show, maybe they got 10 people on the payroll, and you're putting them with Walsh or Shea or Whiting Turner or or whoever, you're putting them with those folks, it really does throw off the balance because they're not able to understand or even with the QC process that the big boys are using. But that's also not to say that I've not seen QC with the big boys fail too. I mean, I've seen $400 million cases that happen because of QC failures on horizontal construction. And
hey guys, if your experience was anything like mine when I was a PM, change orders were kind of a pain. You send the change order, then you spend the next 2 weeks chasing it. Subs are texting you updates. Meanwhile, you have a change order log buried in email. Your spreadsheet doesn't match theirs, and you're just trying to figure out what's actually been approved. Meanwhile, your subs are waiting on answers so they can get paid. The owner doesn't really have the visibility they need into cost exposure, and nobody finds out that the numbers don't reconcile at all until closeout. At which point, everyone suddenly disagrees about everything. That's not a people problem, it's a systems problem. Everybody on the job is working out of their own setup. Your ERP, their spreadsheet, someone else's inbox. Change orders end up getting stuck in the middle of all of it. Well, ClearStory fixes that. It's a shared cloud-based change order log where GCs, specialty contractors, and owners all see the same information in real time, which is key. Subs submit and track their work. GCs stay on top of status. Owners see cost exposure before it becomes a surprise. No more digging through email trying to reconcile the logs at closeout. Just change orders under control, which is a unique concept. Check it out at clearstory.build. What was the cost? Can you say what the cost of those 5 emails from the PM we talked about at the beginning? What did that cost him?
It is about $30 million.
Oh, that's rough. That's a rough day. So tell me this. I think at one point we talked about, how to get in front of some of this, right? And I think you talked about early engagement, kind of spending the money up front. What does early enough actually look like in practice for a proactive kind of general contractor that wants to do it right?
So Lars said something that's very wise because he knows what he's talking about. He was talking about how
hey, blind squirrel.
Lars knows what he's doing. So this is very wise advice though, and I tell this to all my clients. I would rather you pay a small amount up front to have a lawyer, a CM, other support folks come in and oversee the beginning of your project and even through the project. I have a hard hat in my car. I go to projects all the time. I give PM meetings. I give superintendent presentations. I do it all the time. It's good. You should be doing things like that. Have people come in prophylactically, lawyers, accountants, others, CMs, to come in and assist the project from the very beginning. Don't wait until the end. I cannot tell you how many times I have people wait to the end. I had a guy today, I'm dead serious, on my phone, texted me today about the project that I helped him build, was 200 units. He texted me today, it's been years. And he said, hey, I'm about to get a writ of attachment on my property. You guys know what that is, a writ of attachment? It's where they try and take It's where they try and take your property. It's a writ from the Superior Court. And I said, well, you probably should have told me about that maybe a couple of years ago.
Yeah.
Right? Not now. So people do that all the time. They do it all the time. It happens every single month, maybe sometimes multiple times a month to me, where a client will reach out and say, hey, I've got this emergency issue. I need you to represent me in this. Well, why didn't you reach out to me? And I could have set the narrative for you. I mean, most setting the narrative, right?
Yeah.
I need to set the narrative. I'll tell you another really important thing. For example, where you are in the litigation, if you're plaintiff versus defendant, it matters a lot. And people don't know that. They think like, usually you have a claim, right? Both sides usually have a claim. But if you're the plaintiff, the jury hears from you first. The court thinks of you as plaintiff. You're the one who's aggrieved, right?
You're the victim.
You're the victim. But if you wait and you become the defendant, then your entire narrative has now shifted. Now I'm starting from the defense from the very beginning. So you never, this is a big deal to me. Do not wait. Get somebody in there. Have them review your projects up front. You're going to save so much doing it that way.
So, okay, so let's run through a scenario, right? We've got a lot of listeners that are general contractors around the GC side. So we've got a subcontractor that's failing to perform. I'm on my fourth or fifth serial letter. It's like, this is they've even bonded it. We've notified the bonding company. It's just like dead silence. We're like, what are our options, right? Next thing you know, sub walks off the job. I'm asking for a friend here, right? Sub walks off the job, and we're like, what the heck? Next thing you know, we have a lawsuit against us.
Yeah.
Right? And we're like, what? And it's just like outlandish, ridiculous things, right? Okay. And then, okay, well, now I guess we have to countersue or whatever. Not we, again, theoretical, for a friend.
Garrett, did you start your billing clock? This
counts. Stop it. No. This is old business. But in this case, what should said friend, what should that company do when you basically have a non-performing sub? You're like, do I kick them off? Do I file a suit? Do I fire them because the cost to replace is, or do I just try to work with them, right? And oh, by the way, I have a bond. I mean, is that even worth anything? How long is that going to take if I ever make a claim?
These are really good questions because they happen all the time. I'll tell you, using experience from one of these other projects I built. This is a larger one. This is probably 250 units. This is 5 years ago or so. We had a similar issue. A subcontractor, he was a steel guy, okay? He's the one who did all the rebar and everything. He was grossly underperforming. He talking about bidding under just to get the job. This guy had like 2 total employees. He was not self-performing any of it. He was hiring other randos.
He's a broker.
It was very bad. It was very bad. The guy was way in over his head. This project was way too big for him. Anyway, there are a couple ways that we could have handled it. I went to him directly, and we had a meeting, an in-person meeting.
And you're on the GC side.
I'm on the GC side.
Yep.
And I went to him and I said, look, we can run this a couple of different ways. We can get you right off this job, and you know what? We'll figure out what it's going to be, and I'll negotiate with you later. Maybe there'll be nothing. Maybe we'll just wash our hands. We'll get somebody else, and everything's going to be fine. And I had him sign that day a settlement so that his claims were waived, and he couldn't hit us with a lawsuit. Or I said, I could pursue you, and we'll drag this out, and I'll probably destroy your company, and you're going to spend a bunch of money and all that kind of stuff. I find that negotiating in that way and giving people just 2 options really is the way to do it, because most subcontractors, they're too busy. They don't want to, deal with a lawsuit. That guy who sued the friend, all he's looking for ultimately is a payday, right? He doesn't want to go all the way through trial. He's just doing that to try and get some money out of it. Get some money really quickly. And you can solve that get some money issue way earlier than...
I can tell you that in that case, for a friend, that they go to trial and the sub folded.
Yep.
And bond company paid up, and all that stuff. But it was very inefficient, and no one wins. It's just... It's like a little chihuahua biting at your ankles. It's like, just get this thing away from me. Just go away.
I found, unless it's some kind of catastrophic defect.
Right.
If it deals with delay only, if we're dealing with delay only, the vast majority of the time, I'm talking 95% of the time, do not litigate that. It is not a good idea. It's very difficult to do. Experts make that stuff incredibly boring to the jury. Could you imagine the jury, the 18-year-old Starbucks barista, listening into your Primavera 6 presentation? Like, she's going to die.
I like how you talk about baristas. And what I was going to bring back up is, let's talk about the quality of your daily reports and how well your superintendent or whoever writes it, your PM maybe, but is documenting in a very descriptive way those impacts. Because it gets very interesting when there's inconsistencies in how daily reports are written over time. And then it calls into question the integrity of that entire sort of chain of custody of documentation around what occurred out there.
You're bringing up another really good one, another good example.
I've never experienced any of this stuff, Garrett.
Well, that's what you're speaking from great experience.
Friends, I have friends.
I have another case with a situation where that's how we uncovered fraud. We figured out, because the superintendent was so diligent in his daily reports. He wrote down exactly when the subs were working, what times they were working, how many people there were. And then when we got a sub invoice later on, after a dispute, right, a sub came back with post hoc change to this change order, and he blew the change order up with all these extra hours and all these extra people working on it. We sent the guy back a letter, and he's gone now. We sent him a letter that said, hey, our super took diligent notes every day of every person that was on the job, and your hours are fraudulent, right? Yeah. These are post hoc hours that you made up, and we will go to bat all day on this. Like, our guy has notes after notes after notes. You guys have nothing, and they pulled way back after that happened.
And Stephen, forgive me because I'm stealing the mic here, but this is where now it gets really interesting, because how much of the time is spent documenting versus I just need to go out and see my job site. And before you know it, the superintendent never leaves the trailer because he's just documenting all day. Meanwhile, things, subs and quality is running amok. But if you flip it the other way, super field-oriented sub, then the building might be absolutely beautiful, but there's a small little issue.
I think this is the intersection with the rest of our conversation.
100%.
Right? Which is when we talk about technology, this is the opportunity, right? If you've got drone deploy in the air, and you've got OpenSpace, and maybe drone deploy does insides now, which they do. But if you've got a digital record of the project happening daily, and you can extract from that raw data file the signal based on the context or narrative you're attempting to craft, there's some real opportunities to have the best of both worlds. What I want to dig into is something you said to me when we were originally talking, which was, as you look at the landscape of the cases you've interacted with and all the different general contractors and contractors that you've represented, and I asked you, what separates them? I think you said something like, your people are your case. Can you dig into what you meant there?
Oh yeah, big time. Like we were talking about in the beginning, I'm a trial lawyer, right? So trials are all about people and they're about credibility. I'll give you two examples, and they're helpful to illustrate both points. First example is a case that I had about 7 years ago. It was a trial in Orange County. The witness was an expert witness who came up, and he had the most beautiful chart you've ever seen. I mean, I'm talking this is Jackson Pollock stuff. There's all these things going on. There's lines, all these things trying to explain critical path analysis. So he's got this whole thing up, this crazy thing that he must have spent who knows how much time on putting this thing together. Okay, that guy did very poorly on cross not because his cool little painting thing was ineffective, which it kind of was ineffective, but because his credibility was impinged every time he put so much information on the board. There was so much ammo to use on cross that eventually his credibility just wore down over a day of testimony. By contrast, I had another case about 3 years ago. I got this super up on the stand, really young guy, super smart. He got up there and the jury loved him. I mean, absolutely loved the guy. He had no exhibits. He didn't come up there with anything. We didn't even show him any documents. We just asked the guy a bunch of questions. Hey, how do you do your job? How do you perform? What do you remember this particular event? Oh, I remember it very well. I mean, the guy was just a natural, very talented, very smart. And all he did is he exuded credibility. And so when you get somebody up on the stand like that, who exudes the credibility, it's not about how well they're prepared. It's not about how many documents they come with. It's not about how hard they work. It's all about if they're genuine. And if you have people that are credible and genuine and get up there, they're going to knock it out of the park. Yep. And he did. We won that case. It was $26 million.
Better advice is you never even get up there because your people are so credible, right?
Mm-hmm. Yeah.
So,
absolutely.
Well, and we haven't even gotten into the AI side of this. I mean, I can imagine.
Let's go. Garrett already texted me. We've got extra time. Okay.
All right. So, I mean, I can imagine with AI creating so much content, is that adding some wrinkles to what you're interacting with? Like, are you seeing? I mean, like, let's go back to the descriptive versus prescriptive, right? If you're having ChatGPT generate email for you, it's not thinking about this from a litigation standpoint. It's thinking about how do I make the user who's asking the question happy, and they're probably going to get prescriptive, right? So, have you seen any of that show up yet?
Yeah, and I know Lars is going to have a lot to say about this because we go to Blueprint. We've gone a couple of years now in a row.
Did
And
you guys go to Blueprint last year without me? I didn't go last year.
I think we did go last year. Yeah,
I think it was last year. Didn't go this year.
We didn't go this year. But this is the way I view AI. I'm a middle of the road guy. There's people who can't stand AI. They think it's the devil and it's terrible and everything's bad about it. I don't view it that way. And then there's other people who use it for everything. They use it for prescriptively and descriptively. I think that's poor management. I think the AI. I think of it as a tool, just like in your tool bag. It's your drill, it's your wrench. It's just another tool. And all that AI really does, what it does for me, at least in my practice, is if I need to style an email in the right way to meet a client's expectations, I will draft out my email first and I'll give it to ChatGPT and say, "Hey, Chat, help me lower the tone a little bit. My tone's a little accusatory. Help me lower it down." And it's very good. It's really, really talented at massaging and refining things, but it's terrible, awful at providing actual analysis, like deep.
I was gonna say, in fact, I mean, companies listening that are using AI or superintendents, PMs, I love how it can help me organize my thoughts. And in this case, with the right prompt, it can help play defense to your organization around, hey, this looks like an opinion. Like, you probably don't want to say this. And so, again, I'll just say as a matter of procedure, any important email, and there were a lot of important emails that never made it to letters, but a lot of important emails always had multiple eyes on them in my previous company, and no difference than right now, right? And whether it's software, whether it's development and construction, like, it's a team sport, right? And if you're heated and you're sending that thing, you're wrong. I'll just say that you're wrong. You need to sleep on it. You need to ask a friend. You use a tool. Be smarter. The tools exist now.
How about the? Go ahead.
Just super quick on what Lars just said about being smart. I'll tell you one case story. This is an active case, so I won't name the parties. But the president of a very large company that, if I said it, you would know, sent my client, who is the owner of a very significant development company. He sent my client, the president did, an email that he should have absolutely never sent because he was upset. The guy sent my client an email that honestly, it made the whole litigation worse. It made my client more entrenched. It made him upset. It destroyed the narrative that everyone was trying to create to make this thing conciliatory and work together. That one email right there probably cost that guy easy 7 figures, just for no reason whatsoever, just because he was upset. So
Emotions,
be smart,
man. Emotions.
Yeah, be smart.
Emotions and ego. All right, Stephen.
How much margin, or more importantly, how many headaches have you had as a result of margin lost to something that was buried in the documents? A requirement in the spec that didn't match the contract, a flow down clause that shifted risk nobody caught, a conflict between drawings and addenda that showed up 3 months too late as a denied change order. I'm sure each of you guys are experiencing a bit of the cold sweats just thinking about some of those scenarios. So these aren't rare events, as you know. They happen on nearly every project, and most projects just absorb the loss because there hasn't been a better way to manage it. That's what Document Crunch is changing. So Document Crunch is the AI risk management platform built for you guys. It reads construction documents the way your best expert would, identifying and verifying risk with answers you can trust and trace. The trace part of that is really important, as we found with some of these other AI tools out there. Here's what makes it different from general AI. Crunch AI verifies before it answers. Every answer traces back to the exact document, page, and clause it came from. So when your decision gets tested in an OAC meeting or a change order dispute, you know you are on solid ground. It's not just about finding a risk, it's about making sure risk is identified, tracked, and acted on, so nothing gets lost between pre-con and the field. Construction has accepted preventable loss as a cost of doing business for far too long. Document Crunch is setting a new standard. Learn more at documentcrunch.com/construction conversations. Check them out. So, for the PM who's maybe sitting here and saying, like, okay, let's, I am going to phone a friend. And increasingly, like, Claude is that friend for many. If they craft a good prompt that says, hey, you're a construction trial lawyer of 15 plus 2 years. Help me think through the ways in which I can communicate this. What's the flaw? And I guess, is that flawed? And maybe that's the first step, and that's just like you're running ideas through. Like, have you seen any flaws with what AI is producing on that front?
So I think Lars is right that it's very good at organizing. Very good at organizing.
Lars, this is Lars' best episode.
It's because it's the afternoon,
dude. We still got to find the middle ground.
Yeah. Garrett, I appreciate you. Thank you.
Dude,
well, you're right.
Today.
It is true that AI's purpose is largely to help you organize. What I call it is refining. It helps you refine arguments. It helps you understand and better articulate what you're trying to say. Because I know in my mind what I want to say, but I can't get it out on paper. So it's very.
Think how many superintendents can't do that.
Yeah,
right?
Yeah.
Even analyze my daily report, what I miss, and what being consistent with my previous ones, or here's how I like to try to do them. Help me maintain that. Like, that is like what is available partner. Now.
Yeah.
It's unbelievable.
It is. It's a great brainstorming partner, and the coolest part about it is you can upload your daily logs to it and ask it for its opinion.
And by the way, it kind of tells you you're always smart, which drives me nuts a little bit. But red flag. Like, if it tells you great, if it tells you that consistently,
absolutely.
Like, okay, like, time out, dude, time out.
Like, even that, like, you can tweak problem. Your settings in like the personalization, and like I've really amped up the like no challenge me,
yes,
and that's pretty
good.
Helpful. But I like what you're saying, Garrett, which is there's a role to play. But the larger, grander context of maybe the scale of liability that we're considering, you have to take into account as you're leveraging the information you're getting, right?
You do, and you asked a question about what kind of bad stuff do you see? Well, the worst possible thing that could happen is you ask ChatGPT, analyze this for me, and it gives you an opinion, and the opinion is wrong. And a lot of times it is wrong because it doesn't have the full. It's not like you upload the entire project file. You didn't upload all your analyze.
It was trained on like seasons 5 through 8 of like Law and Order. So like, it's
and the crazy thing is, and it's a little scary, it especially on the law. If you ask it a legal question, it will make stuff up that is completely false, like that is not true. So you've got to be super careful about asking it for opinions. That's why I don't use it for that. I use it for, this is what I'm trying to say, and I can't figure out how to say it because it's the afternoon. Help me figure out how to say it in the right way.
Yeah,
and
100%.
That's what it's
absolutely
good.
Love that.
You mentioned a specific AI case around how AI was used to maybe fabricate product information. Did I get that right? That's
the one we were talking about earlier, where the guy, I believe that it was AI that was used to fabricate that. He called it a work log or something like that, a work log. But the reason why I know it's AI and the reason why I know it's fabricated is because AI, the way AI works, right, is uses vectors. It tries to figure out the most probable next word. So when they used AI, I assume it's ChatGPT, to create the document that they did, the AI forgot that there's only 24 hours in a day. So on multiple of the days where they were logging hours, it would write things like, Joe Pablo worked for 116 hours on 5/3. Well, that's impossible because 5/3 doesn't have 116 hours, and he didn't work 24 hours either because my super said he worked 4. So it's stuff like that where you can tell that someone is using something else to manipulate the materials, and I believe it was AI that he used. I don't have confirmation.
No, Your Honor, my Excel spreadsheet was at a time instead of a plus. Yeah.
So, I mean, I think it's a fascinating new world. Because like I said, I was a PM for a number of years, and I never really spent. One, none of my projects ended up in litigation, but two, like it was just never really on my radar to the extent it probably should have been. So to the PM supers, young folks kind of up and coming, what's the message as you kind of position yourself now of like, what should they know? What should they do differently tomorrow?
Are we talking just about AI or just all the stuff?
No, just general kind of construction risk.
Yeah, you were giving a presentation to a general contractor or a sub. What would you go in and say?
Yeah, I think the most important thing is start out early on in the project before the project even starts. I believe very strongly that pre-con is one of the most important things that you can do. I don't like jobs where
we don't have money for that in the budget, though. What do? I'm joking.
Yeah,
I'm joking.
And
it's the first thing to get cut, man.
It's a problem. I understand, and it's a real issue. But I believe that pre-con and getting a lawyer in very early to review the contract to make sure that you understand your risk. I'll tell you another example. I do contracts all the time, AIA contracts. Lars knows my opinion about AIA contracts. I can't stand them for a number of reasons. But those AIA contracts, a lot of people will just sign them. I mean, it's crazy. They're doing like $200 million deals, and they'll just do a standard 201 or a 102.
701 or 70, or no, those are invoices. Yeah, it's the 201.
101, 102 with the 201. And they'll just use those because everybody uses them. And the problem is they are horrific. Like they have things in there like that will tell you that the architect is the initial decision maker. Truly awful for a contractor to have the architect be the initial decision maker on all responsibilities. And it also has, those don't even have mutual consequential damages waivers either. They don't have that, which is a really big problem. Yeah. So what I would do is I would make pre-con very important. I would get a lawyer in there early. I would get a CM in there. It's something that I believe in. I know it's more expense, but I would get one in. And then throughout the job, I consider daily notes as absolute gold. Do you know why? Let me explain just really quick about evidence so your listeners understand how evidence works in a trial. Evidence that is post hoc, evidence that's created after a dispute arises, has drastically low credibility. Jurors understand that like this. They understand it immediately. Like if you throw up a document and be like, well, I prepared this in anticipation of litigation. That document.
What about, does analog versus digital matter? Like if I'm rocking a Remarkable versus like I've got a piece of paper, like a notebook.
I will tell you, it doesn't really matter, but I will tell you that at least visually, optically, I have had some of my best experiences on direct examination. That's when I'm directing my own client. When they have something that's tangible that I can pass around to the jury.
Nice leather-bound moleskin.
Just a small little nugget there. It's not that important. It's nothing like all the other advice we're talking about. But if you could.
You know what it makes me think about? Sorry, real quick. It makes me think about, so I had like a lot of different, like literally moleskin journals. But when OAC meetings would get really boring, I would just like draw in the margins, right? And so like I'm imagining like that journal getting passed around, and there's nothing wrong with the drawings, but it would be like,
have two journals now. Have two journals. It's like two schedules, right? We have our CPM schedule, and then we got our look at it.
This is my official journal.
I think, if I may, post hoc, I think that's really important, right? If things are sort of done after the fact, that's a huge red flag. To me, it goes back to the phrase I was taught, which is the contemporaneous record. It's the record that is built during the course of construction. And if there is consistent documentation, with little to no deviation around that on how that project is documented, meaning the standard is set at the company, and then I don't want to say it's reinforced, but it's put into practice daily through whatever metrics or objectives, right? And that was one thing that it was like, show me the daily report was filed every single day on every single project across my organization. Give me every single sign-in sheet across every single job for that day. And then that record builds up over time so that you can, again, this is how I train the team. It's like you can go to the judge and just say, Judge, forgive me. We did everything we possibly could have in this instance. Every daily report was filed. Every sign-in, every this, all certified payroll, verified, boom, boom, boom. This person's a fraudster. What more could I have done? Now, granted, that's coming from a position of defense rather than offense. But I'll tell you, a lot of times they come after us as a GC.
Yeah. So on your daily reports example, just really quick, I'll use a real live trial where I had to get daily reports in, and I'll tell you the difference. So one time I had daily reports that were in a red spiral bound books like this for multiple years. The books were like this high. And those got in under a rule in California that we call the business records exception. So when you do something that's continuous and a daily kind of event, a routine type of event, and you do it as part of your business, the court will allow that kind of evidence in because it has indicia of reliability, right? You're doing it every day. It's credible. Now, imagine you do that later and you try and do some post hoc thing. The courts will knock that out. I've had stuff like that knocked out before. If you do post hoc analysis and you try and bring that in and say, no, this is actually what happened, right, the indicia of credibility is not there. So not only is it helpful for us, the lawyers, but it's also helpful for you too. When you're developing the project, it's far better to have these contemporaneous routine business documents that are happening every day, not
100%.
Something later.
100%. And that's where, again, production, quality, safety. Those are the three pillars. Doesn't need to be more complex than that.
Garrett, this has been so good.
Can we have him back?
Yeah, definitely.
All right,
Lars, since you're on fire, like, do you want to close out the episode with anything? Any final thoughts?
That's a great question. Yes, thank you, Stephen.
Great question.
I've never been asked it before. I'm honored. Like, this is amazing. No. Okay, so this is good, right? This might be a big one, but for a while, AI has been coming out. Oh, lawyers are dead. Lawyers aren't. There's no future for lawyers, right? AI is going to do it all. I love the smile. And I look at.
There's whiskey in that bottle. You think that giant chug is water? That's whiskey.
No, that's like the 64-ounce Yeti. This dude just drinks straight up moonshine.
He's just sipping moonshine.
Some of the best attorneys I know in construction space actually started out as a project engineer or a young estimator, right out of college. And they're like, this is interesting. And I always wanted to be an attorney. Now I just fell in love with construction. I'm going to be a construction attorney. Do you see a future for real life human being construction attorneys in the future? Or is AI going to take over this space?
No, I don't think AI is going to take over, particularly construction, for a very, very, very long time. And why? It's because what we talked about earlier. AI is a tool. It helps refine arguments. It helps refine your organization. It is not good. It's just frankly not at analysis. It doesn't do very well at judging risk. Like if you ask it to analyze a particular case that I have, it will give you the wrong risk profile.
Right.
And that's because it doesn't have experience in that risk profile. So it doesn't know all the details of your particular project. So that risk profile is always going to be human driven. It's always going to be based on judgment. It's always going to be based on experience. AI doesn't have experience. It just has a list of a bunch of stuff that's been put up on the internet. That's not experience.
So I so appreciate that. And it is interesting because, as a founder, entrepreneur, business owner, there are times where it's like, I absolutely need an attorney. And a lot of times it's when shit's already hit the fan, right? It's like, crap, I got a problem. And there are times where it's like, I should have made calls earlier on. Now, in previous company, I had an attorney on staff, right? And it was to arguably protect around that. But I had a recent instance of, we'll call it, pursuing a potential protest against the federal government around set-aside contracts, pursuant to the White House directive around sort of non-socioeconomic set-asides. And I'm like, this stuff's just fascinating, right? But I can't remember, Stephen, if I sent you the prompt, but it was one of the most amazing prompts. And Garrett, I should just send you the analysis it came up with, because it basically said, my protest has no grounds because of X, Y, and Z. And I was like, and based on my experience, I knew okay, that's legit. Hey, I'm not sure about that reference or what CFR. I'm going to go look at, okay, yep, okay. And then the nuance of the instruction or an executive order versus like a CFR, and I'm like, oh, this, or a FAR, like this is cool stuff. So anyway, but I look at that as that's just a tool now that a guy like you and I can have just a better discussion. Yeah. Right? It's just more information, access to more analysis, more information that speeds things up, that makes us, more informed and all of that. And I'm thankful to hear that no, there's no AI that's going to replace a construction attorney. Absolutely not. And
I don't think it's going to replace a construction attorney. I don't think it's going to replace really anything in the industry, period. Because the industry is so human driven. It's the industry is so network driven too. Like it's based on who you know, not what you know. Right? There's a lot of guys out there who know a lot about construction, but
it's such a physical world. It's so physical. It's not healthcare records. It's structure, and there's risk to structure.
I think that's why, frankly, when we go to Blueprint, it's hard for a lot of these companies to get off the ground versus, say, in data centers or in medicine. Those kind of companies, they get off the ground because it's easier to do in those industries. Our industry, it doesn't work that way. It's very people-based.
Yeah.
Lars, you're not allowed to close out the episode anymore.
There was another question. It wasn't a closing. All right, fine. Here's my closing question. Would you have done anything different, Garrett, or do you love what you do?
I love what I do. I would say do something on the side.
Moonlighting. Bartender over here. Probably makes his own whiskey in his garage.
I really enjoy. I'm an apologist, and I love going around to churches and schools and teaching, being an apologist. I think it works really well with my trial lawyer skills. So I really enjoy that. It's a lot of fun.
I mean, a lot of people aren't going to understand what that means, but I do, and I can appreciate that. And I don't say it like I do, like I'm smarter than others. But maybe like dig into that, because I think the idea of an apologist is a little bit of an archaic term, right? Like it comes from the school of oratory, but go into it.
Yeah, an apologist, in particular, apologia, it doesn't mean to apologize. It means defense, right? So it's defense of the faith, and I'm Christian, so. What I go around as apologist just means that you're going around and you're defending your position. And so it's a perfect thing for a lawyer to do. And I find it fascinating because when I go into schools, when I go into churches and I talk and ask questions of the kids, they have amazing questions back. I mean, if you ever talk to kids for 20 minutes about science and the universe and all that kind of stuff, they will give you the most amazing, wise questions, far wiser than you'll get from adults. Most adults are pretty set in their ways. Children are very, very wise.
The questions my 8-year-old asks me after I'm putting him down to sleep and as I'm walking out the door are some of the deepest questions you'll ever.
Pulling you back, man. It's not bedtime
Can
yet.
You describe the triune God.
Yeah, there you go. I had that one a couple weeks ago. My 7-year-old asked me that. He's like, describe to me the triune nature of God. I was like, ooh, that's
wow. Okay.
Yeah, all right,
that'll be over bacon and eggs in the morning.
Let me get my bottle of moonshine.
Yeah, I gotta get this out.
That's terrific. I love that. I mean, that is kind of a lost art a little bit. And one of my favorite authors, theologians, is G.K. Chesterton.
Yeah.
And a lot of his writing was essentially that in kind of written form. So that's fantastic. Garrett, you're the man. For the folks that are listening, they're like, well, I actually need a Garrett in my life. How do they contact you? We can put whatever we need to in the show notes.
Yeah, we'll put them in the show notes, but just really quick, my email is really easy. It's just my name, Garrett.Mott@Hennig, that's HENNIGH, law.com.
Fantastic. All right, Lars. Thanks for bringing afternoon Lars energy. I enjoyed that.
My pleasure, Steve.
All right, see you, Garrett.
Thanks, Leslie.